Everybody, my name is Dave Stous. I'm a partner at Husch Blackwell and member of the Privacy and Cybersecurity Practice Group. Thank you for joining us today for our webinar on state AI regulatory landscape and what to expect in 2025. I want to introduce you first to the speakers that you will hear from today. I've got their pictures up on this slide, and the QR codes will take you to their LinkedIn pages. If you like following us, if this is the first time you've interacted with us, we push out a lot of content on our blog, and we'll have a slide on that at the end, but also push out a lot of content on LinkedIn. So if this topic interests you, then maybe following us on LinkedIn would also be of interest to you. While I have this slide up here, I just want to have a couple housekeeping items. If you have questions, feel free to ask them. We'll do our best to answer them. As other people are talking, we can jump in and the other presenters can try to answer them during the presentation. But if you've attended one of our previous webinars, you know that we try to max out our hours with content. And on this subject in particular, it's a lot. And we're going to be trying to really max it out the time that we have here. So we may not get to all of your questions. And as other folks will tell you as well, inevitably I talk too much, and that also hurts us on time frame as well. Second thing, we offer CLE credits. That's about as much as I know about how the CLE credit process works. I understand that there is an icon that you can click on to get CLE credit, and I think there's an email that comes in later, but we have great staff here. If you have questions about your CLEs, just send me an email, I'll connect you with them, and we'll get you all set. I know we're getting close to year-end compliance. I know very well we're getting close to year-end compliance. Okay, so if you've attended one of our previous webinars, you know I like to start off with roadmaps. I think this helps you guys understand where we're going. It helps avoid some of the questions that come in as well, and kind of level set about what topics we're going to talk about. So first, we're going to give you a 2024 overview. You'll hear from me on that portion of it. Have some interesting topics and slides on that one in particular. Then we're going to pivot, and Shelby's going to take over for a little bit and talk about private sector laws that passed in 2024. So they'll be the ones you've kind of heard about. We're going to present those to you, hopefully in a way that you can understand them and synthesize them. Then we're going to talk about what's coming, 2025, notable bills and regulations. We've already got a fair amount pre-filed, and a few states have some carryover bills. So it's only December 11th, but we're already getting geared up for 2025, and it's going to be a lot. And then finally, we'll get to the Colorado AI Task Force. We're all here in Denver, Colorado, the presenters here today. And there's been a task force ongoing with respect to potentially revising, I should say, the Colorado AI Act that passed last year. Shelby will take you through an update of kind of what they've been talking about with respect to that. Okay, so let me jump in then and get you through the 2024 overview. Start with this slide. Trying to have a bit of fun with this introductory slide. We came up with these rankings. This is more of an art form than an exact science here. So feel free to send me your complaints if you don't like the rankings here. But it's what it's intended to be, is basically a high level way of giving you a snapshot of what happened last year. And by last year, I mean 2024. Obviously, we're still in that year, but in 2024, I should say. We're going to go into further detail in the coming slides about all of these topics here. But I think what I wanted to really relay with this slide is that AI is far more complicated. The topic of AI bills and regulations is really far more complicated than what we've seen in privacy, right? And so a lot of you have been tracking us throughout the years on Bite Back. And you know that when the legislative sessions start, the state legislative sessions, we do these weekly updates. And it has, the bills that are tracking on every single month or every single week, and we do that for all the different states. And so we do that. It's very narrow, right? I mean, state privacy bills, we've added things over the course of time, like we've added some AI stuff and consumer health bills. We've added some other topics as well, like data broker bills. AI is far, far, far more complex and far more nuanced than that. So we're going to dig into that, but I think that really comes through in this slide, or hopefully it does come through in this slide. You also see states like Maryland and Florida that are on the top of our states to watch. That might surprise you, but as you'll see in the coming slides, those states actually considered a lot of AI bills last year. It didn't get a lot of noise and a lot of traction, but they consider a lot. So let's dig in then, go to the next slide. So AI bills in 2024, by our count, and it's hard to count exactly AI bills. I'll get into that in a little bit. But by our count, 477 bills were proposed at the state level, okay? They were across 45 different states. inclusive of Washington, D.C., Puerto Rico, and the U.S. Virgin Islands. Now, keep in mind that in 2024, there were 4 state legislatures that were not in session. North Dakota, Texas, Montana, and Nevada were not in session. They're every other year legislatures. So basically, we only had 1 state where we can find, based on our research, that did not have a proposed AI bill. And that's pretty notable when you're thinking about the scope of what we're talking about. It's also worth noting, too, that there are a few legislatures that are still open. So Massachusetts is still open, Michigan, New Jersey, and Ohio. Those legislatures are still open right now. We could see something happen by the end of the year. I don't want to suggest that the legislative sessions are all closed right now, but this is where we sort of stand now. I will say with Michigan, if you've watched us or you paid attention to us on the privacy space, keep an eye on Michigan. The legislature closed in just a few days here. There's a couple of bills, consumer privacy and health bills, that we're paying a lot of attention to. So stay tuned there. Okay, so top 5 most active AI states, and this might come as a surprise to you. There's a few different ways you can kind of divide this up, right? If you considered which states introduced the most AI bills, then New York would be the front runner with 80 bills that we counted that they introduced. However, only one of those was signed. And so what we really did here when we were trying to rank here is we came up with like bill signed, right, as most active states. Again, you could have introduced and it would be a different format here. So leading the charge here is California, which introduced 41 AI bills, 13 were signed, 28 did not make it across the finish line. 4 bills were vetoed by the governor. We're going to talk about 1 or 2 of those later. Owen's going to talk about those. Maryland, we have 8 bills passed. And again, like we're talking about all AI bills, right? We're not just talking about like private sector bills. We're talking about all AI bills. And I have a slide in a second that's going to kind of show you some more of those. Utah then is number 3, followed by Florida and followed by Illinois. What you see again, I mean, these numbers, when we pulled them and I looked at them, this was surprising to me. It was surprising, not California. I think everybody knows California. We were tracking those with weekly updates towards the end. But the other states are really surprising to me. And again, it's just suggestive of the fact that we really only see a small piece of the puzzle when we're trying to look at like weekly updates and stuff. Okay, the types of state AI bills. So what we ended up doing was taking those 477 bills and trying to categorize them. It's kind of a fool's errand to try to categorize these things. Many of these blend together, but we wanted to kind of show you guys like the scope of what we're really talking about. So we had them ultimately fall into 23 different categories. We've shown 11 of the categories up on this slide, and the next couple slides I'll show you have a few more categories here. So what does this tell us then? It tells us again that these bills are all over the place in terms of topics. At least on this analysis here, government use was our top one at 17%, and government use would be the bills that focus on the use of AI by government agencies and law enforcement. You also note that other at the top there is 17% as well. I'll talk about that category. We'll break it down further in the subsequent slides. Private sector use is 15%, and that would be bills that are focused on private sector businesses and organizations. And then responsible business use bills are 10%, and that would be bills that are things like algorithmic discrimination bills based on harms that protected characteristics like race and sex, religion, or disability. And then, just sort of one more topic there, study bills, that's 8%. That's bills focused on legislation requiring an AI study or task force, right, at the state level. Again, things blend together, right? You can have bills that touch multiple topics, in particular, like the private sector use and the responsible use, very hard to like categorize there. So, you're definitely going to get overlap. Don't be hypercritical of this slide. It's really intended at the end of the day to show you guys the big diversity that we're seeing with AI bills that are out there. I mentioned before that other category was 17%. So we tried to spend a couple of slides breaking that down a little bit for you into what we have. And this is the first slide here. I mean, things like appropriation, CSAM, and Providence are the ones that are shown on this slide. The next one is in my mind, again, just kind of going through top to bottom here, really sort of interesting topics here, right? Judicial use is one that we saw, obviously only 1%, so not a large number. I will say, in putting this together, personhood really caught my attention. That's one where AI can be granted personhood. And when I kind of look at that one, I think, man, what a world we live in, right? That we're considering bills about AI having personhood. Okay, So enough about me and the high-level analysis of these bills. I will next turn it over to Shelby, who's going to talk to you about notable private sector laws passed in 2024.
Thanks, Dave. Hi, everyone. So let's jump into private sector laws that actually passed in 2024. Since we all are based in Denver, like Dave mentioned, the first one on our list, of course, had to be the Colorado AI Act. The Colorado AI Act is the first of its kind in the space. The first thing of note is that unlike what we see with consumer data privacy laws, this AI law does not have any consumer or revenue thresholds required for the act to be applicable. The law instead applies to any deployers or developers of high-risk systems that are deployed to consumers in Colorado. This law really is specifically targeting high-risk AI systems. These types of systems are defined under the law as any AI system that, when deployed, either makes or is a substantial factor in making a consequential decision. Under the law, a consequential decision is a decision that either affects the provision of, denial of, any cost or terms of education, employment, financial or lending services, government services, healthcare, housing, insurance, or legal services. I do want to note that the law does specifically lay out a number of exclusions for using AI systems that wouldn't be considered a high-risk AI system, including using a system for anti-fraud, security purposes, antivirus, some of those types of exclusions that we see under data privacy laws. So as I mentioned, this law applies if the high-risk AI systems are being deployed to consumers in Colorado. In contrast to the Colorado Privacy Act, the AI law actually applies to consumers who are considered any state resident that interacts with that system. So here, the law actually doesn't exempt employees from the definition of a consumer. So unlike the consumer privacy law, this law is going to apply to employers who are deploying a high-risk AI system internally and using it with their employees. So lastly, how will this be enforced? There is no private right of action, but the Attorney General's office will enforce this law, and there can be up to $20,000 per violation. I did want to highlight that we took a deeper dive into this law on our Colorado AI Act webinar that you can access via the QR code here. We outlined in more depth developers versus deployers and the requirements for each role. And I'm going to touch on this later, as Dave mentioned, but there is currently an AI task force that is working on reviewing and revising this law. So although this law is set to go into effect February 1st, 2026, we may see changes before then. So keep that in mind, and I'll be back later to talk about the task force. But for now, I'm going to pass it over to Owen to talk about California.
Thanks, Shelby. So as Dave mentioned, a lot of the AI bills we saw last year were considered and passed in California. Today, we're just going to highlight 4 of those. So the first is AB 2885. This is really just a kind of a definitional statute. It amends current laws in California to incorporate a definition of artificial intelligence. And the definition closely aligns with kind of that same definition that we've seen in a lot of other bills that we'll get into more detail later. The laws in which it incorporates this definition, a lot of them apply to state agencies, but there are some that apply to private companies. And that bill goes into effect January 1st of 2025. The next one is a bit more interesting, AB 2013. So this one basically says that developers of generative AI systems or services must make certain disclosures on their website. And this is sort of, it's described as a high-level summary of the data sets that the system uses. This law goes into effect January 1 of 2026. One thing that we're keeping our eye on is the bill is targeted towards developers of AI, but it also applies to users of generative AI systems that substantially modify the AI system that they're using. So to what extent, what we commonly refer to as deployers of AI systems, to what extent they'll be required to comply with some of these disclosure obligations is yet to be seen. So the final bill here is SB 942. This also goes into effect January 1st of 2026. It creates transparency obligations for companies that create code or otherwise produce generative AI systems. Basically, it requires companies, and note there that it only applies to companies that have 1 million monthly visitors for their generative AI system. But it requires developing tools for people to identify if some content has been created by generative AI. It also requires you to include sort of latent signifiers within the content that you create so that it can be identified as generative AI content. So the last California bill to mention is one that was vetoed, as Dave referenced earlier. This is the one that got a lot of attention in the news last year, SB 1047. OpenAI and Anthropic came out with statements regarding the bill. It did pass the legislature, but then Governor Newsom vetoed the bill. Now, this bill would have only applied to the largest foundation and frontier models. It triggered application if the system or if the model cost, I think it was $100 million to develop or $10 million to fine tune. When Governor Newsom vetoed the bill, his specific criticism was that it was too focused on size and not focused enough on the specific use case for the the AI foundation model. Compared to most of the bills that we have seen, like the Colorado AI Act, this bill was not focused on significant decision making. So that's the reason that Governor Newsom vetoed the bill. All right, moving to other states, we have Utah SB 149. This was a bill that was passed earlier last year and went into effect May 1st, 2024. This bill basically says that Utah's current consumer protection laws apply even if you're using generative AI to accomplish some task or interact with a consumer. It does add some new disclosure requirements. For most companies using generative AI to interact with consumers, you have to provide a disclosure of the use of generative AI if a consumer asks you to or you're prompted to by the consumer. There is a subset of companies that have to license with Utah state government, think like accountants, architects, and the law says that if you're doing that type of business and you're using generative AI, then you have an affirmative obligation to disclose the use of Gen AI in that instance. Finally, the bill also creates this Office of Artificial Intelligence Policy, which is basically think that it's like a think tank that's going to the purpose of which is to kind of think about and recommend future AI regulation. Moving to Illinois, we have HB 3773. This one goes into effect January 1st of 2026. Essentially, this is a bill that amends Illinois' current anti-discrimination law to say that you can't discriminate against people and their protected classes by using artificial intelligence. It specifically targets the employment context. So as we say there, targets recruitment, hiring, promotion, etc. The bill also says that it's a civil rights violation for an employer to fail to provide notice to an employee that the employer is using artificial intelligence. There's not a lot of detail given on how that notice has to be provided. The bill is going to be enforced by the Illinois Department of Human Rights and the Illinois Human Rights Commission. The department is specifically charged with doing some rulemaking on this bill that we expect to see, coming in the next few months, and we anticipate that they will, provide regulations on how you're supposed to provide this notice. And as mentioned there, because this is Illinois' anti-discrimination law applicable to employers, there's a process by which harmed employees can file a charge with the Department of Human Rights before litigating, a claim against an employer in either with the commission or in court. All right, now I'll pass it on to Eric to discuss sector-specific developments for AI systems in 2024.
Thanks, Owen. Hi, everyone. We're going to change gears for the moment, and instead of looking at state legislatures and the activities that took place, we're going to talk about a couple of items at the federal level, and then also for New York State, we're going to look at how the Department of Financial Services took existing regulations and through a guidance letter broadened the scope of interpretation when it comes to the handling of AI risk management for covered entities within that sector. So we'd be remiss if we didn't address federalism and looked at the US government writ large for a moment. Recent activity that we've seen, and this, the big caveat that I would offer here is with the change of administrations going to take place in January, some of the efforts that we have seen coming out of the federal government in the last month, if not last 9 months, are probably going to be modified either through executive order or through heightened enthusiasm or reduced enthusiasm and reduced funding, depending on the nuances and the specifics of the project. But for the time being, let's talk about the most recent which was the Department of Homeland Security publishing a roles and responsibilities framework for AI in critical infrastructure. And I call your attention to the left-hand part of this slide here. The framework is predicated on President Biden's Executive Order 14110. And the reason that I call that order out specifically is President-elect Trump has said that he is going to rescind that order right when he gets into office. Biden's executive order had laid out a series of directives to the Department of Commerce and to other federal agencies on steps to take with artificial intelligence on the governance side. And it remains to be seen whether President-elect Trump will rewrite and alter some of that guidance, or whether he will rescind it and remain silent on these topics. So this roles and responsibilities framework is interesting because it is voluntary in nature. There is no compulsory requirement that goes with it. It is focused on critical infrastructure, and it looks at increasing and facilitating collaboration across the supply chain. And as you see in the graphic on the right-hand side, it identifies particular stakeholders and then pillars and concepts within that framework that each of those stakeholder groups needs to be thinking about. So that's where that one stands. I view that as being somewhat in contrast to two of the earlier federal initiatives that we saw for AI within the National Institute of Standards and Technology and the Department of Commerce. The first being the Artificial Intelligence Risk Management Framework and the United States AI Safety Institute that came out of President Biden's order. And the reason that I'm calling that one out specifically is we've seen comments from bipartisan legislators at the federal level, both Republican and Democratic congressional reps and U.S. senators that have expressed support for what the U.S. AI Safety Institute is doing. So reading the tea leaves on that, there's been legislation that's been thought about for formalizing what that Safety Institute is doing and moving that program forward. So we'll keep an eye on what happens at the federal level there in order to contrast it to what we're seeing at the state level, which, as we'll talk about in the next segment, has different approaches to the topics. The other off-track or unique approach that we saw was with the New York Department of Financial Services issued an industry guidance letter for AI risks. I find this interesting for two reasons. First of all, they take their existing cybersecurity regulations, which are codified at 23 NYCCR 500, and that gets a lot of attention because everyone, if they're subject to New York DFS regulations and authority, you have 72 hours to report a cybersecurity incident. What the guidance letter tells those covered entities, those financial institutions subject to New York state law, is they need to factor in the risks of artificial intelligence when they are submitting their annual reports under the notices to the superintendent that they have complied with the cybersecurity regulations for the last year. So that means a regulated entity needs to think about the risks from AI, but the letter then goes beyond that and says that the same regulated entities should be thinking about the defensive measures that AI can bring to bear to improve cybersecurity risks. Those are kind of in that yellow block on the right-hand part of your slide as far as some of the examples that can be done or take where AI can be utilized to improve a cybersecurity posture. And the last part of the guidance that we found interesting is that NYDFS points out that covered entities need to be broad in their analysis on how they are viewing the risks of AI, not only to the extent that they are deploying an AI product within their network or as far as interacting with consumers, but they also need to be thinking about how AI can be used to target their networks and the risks and threats that the technology presents to their industry. So with that, I'm going to give the mic back over to Dave, and we're going to start the conversation on 2025 and interoperability between legislative efforts for the new year.
Yeah, thanks, Eric. Before I begin, just two bookmarks on this. One is, I think on the previous slide in Colorado AI Act, it said prior right of action. There's no prior right of action under Colorado AI Act. It's my mistake there. I dropped the word no off in the revision process, but no PRA in Colorado under the AI Act or under the Colorado Privacy Act for that matter. Second thing is lots of questions in here about nuances of the bills. Great questions. Keep them coming. There's obviously, in particular, like with the California bills, but I did want to bookmark is, while this is like a high level, hey, this is what's happened in the industry and this is where it's going to go in 2025 webinar, we have produced a ton of content on Bite Back in particular with respect to a number of these topics that people are asking questions on. So, for example, we've done a full webinar, as Shelby mentioned, on the AI Act on Bite Back. It's accessible there, I should say. We've done on-demand webinars on the Colorado ADMT regulations, articles on Colorado, Illinois, and as well as the California bill. So if you're looking for more detail or nuance, you may find the answer there, may not, but obviously it's hard with so many bills and so many things happening to give every single piece of the puzzle here. Okay, with that big wind up, Eric had said, we're going to shift and talk about 2025, right? So I wanted to start here. There was, and let me start at this piece of the puzzle. So there's a multi-state work group that was run 2 summers ago. It was led by Senator Maroney. And you may know that work group because it ultimately was resulted in Connecticut SB2, Senate Bill 2, and it ultimately resulted in the Colorado AI Act. The concept there was to bring a bunch of folks at the state level who are interested in running bills on AI, bring them together, have people who are considered experts in the field talk to those lawmakers, give presentations to those lawmakers about their various areas of expertise, and then have the lawmakers be able to work together in some fashion on coming up with interoperable bills. And so there was, depending on how you want to look at it, there was some success out of that one with Senate Bill 2 got through the Senate last year, died in the House, the Connecticut bill did, but the Colorado AI Act passed. Senator Maroney, the Connecticut Senator Maroney, ran the work group again this year. I asked him for some background to lead up for this webinar. I asked him for some background information on where things stand with that work group. And so this is the information he was willing to provide. I said there's almost 250 lawmakers across 47 states that are part of their mailing list. So obviously it's a very large number of lawmakers. He said it's less number who are actively showing up in every single work group meeting. I think it's a little bit less than 50, but still a large number of lawmakers who are paying attention to the multi-state work group. It's bipartisan. There's Democrats and there's also Republicans. So it's been a bipartisan effort. And I think that's been an important piece of the puzzle as well. They're meeting about twice a month right now in the lead up to the legislative cycles starting in, basically they tend to start in January. Other states, are different. And again, the goal remains the same from what I understand. The goal is to have interoperability between and across state bills. Kind of the recognition that this is incredibly difficult to do. Similar as the privacy space, this is incredibly difficult to do if states are going out on their own and doing things individually. Obviously, that can still happen, but this is an effort to at least be interoperable. I did ask the question of, hey, what do you think comes out of this one? And, the prevailing wisdom now, at least, and we'll see what happens, but the prevailing wisdom now would be about 10 to 12 states could run bills that are in kind of this model that is this SB2 Colorado AI Act model. Again, remains to be seen, but I think that's sort of what they're thinking right now. Okay, I mentioned SB2 a couple times, maybe more than a couple times, with the last slide. So just to level set here, it's coming back. There's already a draft bill in circulation for the 2025 version of the bill is in circulation for comments right now. What ended up with that bill last year is it passed the Senate. It had wide support in the Senate, primarily along party lines, but it didn't advance in the House, and that was after the governor indicated that he would threaten a veto, and so it never made it to a House vote. But Senator Maroney's back working on that bill through the work group, and we certainly expect to see it will be introduced at the start of the session. Okay, let me hand it back to Eric, who can talk about Texas.
Okay, thanks, Dave. So, we began the numerical breakdown at the beginning and talking about which states have done, what level of effort when it came to AI legislation. Keep in mind, one of the caveats that can play a role in that factor is how often the legislature meets. So Texas is a state that meets every other year. Generally, their schedule for this upcoming year of 2025 is going to be from January to June, and then their next normal session would kick off in 2027. So one of the bills that's been introduced has been sponsored by Texas State Representative Giovanni Capriglione. And it's interesting because his background and the roles that he has with the multi-state efforts on artificial intelligence are very similar to Connecticut State Senator Maroney that Dave just talked about. You can see on the first box up there, the bullets and the areas where they're involved are, the same working groups that are attempting to harmonize or find a way to make these laws at the state level interoperable to avoid some of the patchwork challenges that we saw with data breach notification laws when they began to debut. The other piece that we have on here is that what the Texas Responsible AI Governance Act, or TRAGA, as it's been referred to by some commentators, is looking to do, if someone is a red state Republican counterpart to the Connecticut legislation that Dave just talked about. Representative Capriglione's got a background in business and technology. He wants Texas to be the global center of AI. And his contention is that he's gathered inputs from 300 industry experts that led into the contents of the bill that he's putting out. So what we can think about that, what does it look to do? In my mind, the bill is focused on 4 different concepts of accountability that would be applied to developers and deployers, giving some empowerment to consumers to understand when they are interacting with artificial intelligence systems, and then also give them some rights of redress. There's an enforcement mechanism with the Texas Attorney General, and then there are 2 aspects of the bill that, if it goes in its current form, are pretty innovative, and we'll talk about those as well. As Shelby mentioned, and when we think about the Colorado AI Act is focused on high-risk systems, that's the same for the Texas law bill as well. A high-risk artificial intelligence system, or HIRAS, is any artificial intelligence system that, when deployed, makes or contributes to the decision-making of a consequential decision, very similar to what we see with the Colorado law. One group that's exempt from compliance with this bill, as proposed, would be small businesses. So if you are an entity that is defined by the Small Business Administration, then you would be exempt from all of these compliance requirements. What does the sandbox do, and what does the AI Council that the bill do? A couple of things. So the AI regulatory sandbox that is proposed in this bill would be an area where AI technology can be tested without the fear of having to meet all of the compliance requirements for a temporary period of time. So it's to foster innovation and allow for a system to come out of beta, come out of the lab, so to speak, and be used in a broader environment to be put through its paces and see if it's performing and operating in a manner that was designed or intended with the outcome. The AI Council is an organization that would be part of the Texas Office of the Governor, and it's going to have two powers. One is to offer advisory opinions to agencies and also to the Attorney General on safe and ethical use of AI. What I haven't been able to determine from how the bill is written now, and this will pan out as it goes through debate and we get greater clarity on it, is whether the AI Council would be something of, a neutral expert witness, for lack of a better term, that would opine on a particular system and whether it's in compliance, whether it's operating safely, whether it's operating in an ethical manner, and whether various Texas state agencies can use the AI Council's opinion as the basis for enforcement or not. So, put a pin on that topic for the moment because we aren't certain yet where that is going to move from a conceptual standpoint. When it comes to the requirements for developers and deployers, the definitions are relatively the same to what we see in other legislation. A developer is an organization that builds or designs a system that they offer out to the private sector or to the public sector for use. A deployer is the organization that implements and puts that system into business that is then interacting with customers or consumers. There are prohibited uses that the Texas bill lays out, and they are very similar to what we see for the European Union's AI Act, but not identical. So some of the unacceptable prohibited activities would be using AI for behavior manipulation or for social scoring or for emotional recognition. Some of those things that where a consumer may not be aware that it is, in a sense, going up against a machine that might be negotiating or making decisions on what rights or opportunities an individual might have. So the bill spells out that list of prohibited activities. Once you get to the high-risk systems, then we are looking at requirements on the reporting side, both for the developers and the deployers. The developer is going to have to give a risk report to every deployer that receives the AI system on where it could potentially go wrong or how it should be behaving. The deployer is then going to have to complete an impact assessment and develop a risk management policy before putting it to use in a public-facing manner. The other part that's somewhat unique on this bill is almost the analogy of if you modify it, you own it. And where that comes into play is if a deployer takes an AI system, but then substantially modifies it to either transform it into a high-risk system, or if they modify the functionality of an existing high-risk system, then the law would consider that organization that made the modification to now be a developer, and the organization would take on those same obligations. The level of detail and the level of specifics and what those reports and what those impact assessments need to do, I'm going to hold off on discussing those until we get further through the legislative activity and see what the requirements really look like. Other requirements for the deployers. Up at the top, they have to use reasonable care to protect consumers from foreseeable algorithmic discrimination. That same burden is in place for a developer. So anybody that is involved in designing the systems, putting them to use, is going to have that standard of care that they need to meet. If a deployer sees in its monitoring of the outcomes that the high-risk AI system is generating that the system is not doing what it's intended, if it's departing from the baseline, if it appears to be generating unfair or biased outcomes, the deployer has an obligation to go back to the developer or to the distributor, if there's a middleman, and inform them of the problem. The deployer also has an obligation to be training its personnel to oversee and monitor how the high-risk system performs to identify those deviations. On the transparency side, this is where we get into some of that consumer empowerment. A deployer of a high-risk AI system needs to disclose to each consumer before or at the time of interaction that the consumer is talking to an artificial intelligence system. So when we think about those point of collection and whether we can just put this into a privacy policy and have it sort of in the background, or whether we need to be more upfront about it, My reading of how the bill is written at the moment is that this interaction and this disclosure needs to be more right at the time that the conversations with that AI system are about to begin. What about the enforcement side of life? Here, there's two aspects of it. The Texas Attorney General is the one that is empowered to investigate if there's a finding of violations, notify a business that their system appears to be in violation with this future Texas law, have a 30-day opportunity for cure, and if the cure is not satisfactory, issue an administrative fine. So that's the power that the Attorney General has. Consumers have a limited right in this sense. So it's different from the private right of action that we see in other laws where there is monetary redress that a consumer can get. But if a consumer can demonstrate that they are being harmed by an AI system that's engaged in a prohibited activity, engaged in one of those prohibited activities that we talked about earlier, then they can seek redress to get declaratory and injunctive relief, as well as attorney's fees and costs. So there's not a monetary penalty that's associated with that, but there is the right for a consumer to take action in the narrow field of prohibited activities. A consumer also has the right to appeal a decision made by a high-risk AI system and to have human oversight and have an explanation of how that decision was reached. So that's everything on the Texas law. As we said, this is still at the bill stage, and we will see what it looks like in final form, and I'm going to hand it back over to Shelby.
Thanks, Eric. So I'm going to move us on to carryover bills. The only two states with bills that could carry over into 2025 are New Jersey and Virginia. Looking first to New Jersey, the legislature actually introduced 26 different bills this year related to AI. And at Husch, we tracked 7 of these bills that were specifically focused on AI. New Jersey currently has an active legislator until next week, ending on December 19th. So we are not going to do a deep dive into each bill since it isn't clear if these bills will actually carry over. So to give a brief overview, we have AB 4030, AB 3854, SB 1588, which all regulate the use of automated employment decision tools during the employment decision process. And these bills require companies to minimize any discrimination that may result from the use of such tools. The last action we saw for these bills was a committee referral back in May. SB 3015 and AB 3911 also focus on the employment decision process, but instead regulate the use of AI-enabled video interviews during the hiring process. So I'm sure we've heard more about this type of interview process as of late. So that's what these bills are trying to address. And the last action was a committee referral back in April. And then lastly, for New Jersey, we have SB 2964 and AB 3855, which establish standards for conducting independent bias auditing for any use of automated employment decision tools. So if you think back to that chart that Dave was going over, that kind of pie chart that Dave was going over in the beginning, all 7 of these bills fit in that employment decision bucket. Since there has been no movement on these bills since early spring, it's really going to be interesting to see whether these are carried over into 2025. And so Dave is going to cover Virginia's carryover bills.
Yeah, thanks, Shelby. So Virginia is also one of those states that has bills that carried over from the previous legislative. This one and the next one, it kind of goes over the bills that we identified. I think there's a gatekeeping issue, though, with respect to the Virginia stuff, which is Virginia's got a really short session this year, at least according to the legislative website. It opens on January 8th and it ends on February 22nd. So, sort of a lightning quick legislative session. I think, you have to kind of take these bills, these carryover bills through that prism, right? The one I think is top of mind for me is 747. That's Michelle Maldonado's bill, an AI Developer Act, somewhere in kind to the Colorado AI Act, the SB2 type bills. And my understanding is that bill was reported out of the Joint Commission on Technology and Science recently. So it's moving. I think it's still in draft version. I think my understanding is it's still being worked on. But I think as far as looking at Virginia, again, it's going to be that shotgun approach to given the short legislative cycle. These are the other two bills we've identified. Again, we're trying to, I won't go into these bills in the interest of time, but we're trying to give you the slide deck so you have more information rather than less. But just a couple more bills we'll be taking a look at this year. Other notable bills. So I spent Saturday night going through the legislative scanning sites and was identifying the bills that we've already sort of seen introduced or pre-filed this for the upcoming session. No surprise to see California at the top of the list. These are like intent bills or placeholder bills. So there's no like text to them yet. I think the synthetic content might have a little bit of text to it. But what they typically do in California is they'll have a bill, they'll assign a bill number to it, they'll have some language to it. But then as the deadlines come up, then they'll use those as placeholders and we'll drop the bills in. They move bills all around. It's a very active process. So no surprise to see that California wouldn't already have some bills that are on the way. I think the California legislative session has already started very quickly after it ended before. Missouri, a couple of bills that are filed there. Use of AI and property assessments caught my attention there. Nevada is one of those every other legislative cycle years. So we have a pre-filed one on synthetic media content, and Illinois comes back again with another bill. Again, these are bills, right? I mean, it doesn't mean they have any momentum whatsoever, but these are just things that we're seeing filed already. Texas. I mean, Eric talked a lot about Texas, right? I want to tell you is it's a hotbed, and it's one of those every other legislative cycles. I've got 3 bills identified here. I sort of ran out of steam on the Texas one. I think there was probably 8 or 10 more AI bills that I could have put on the slide, and I kind of thought, man, this will be overkill for everybody, right? So I gave you 3 that I thought were interesting, but there's a heck of a lot more bills that are out there in Texas, and that makes sense given that they didn't have an opportunity last year with the legislative cycle being every other year. Montana's the same thing. Montana's every other year. The way Montana does it is they'll have you can see that they're drafting bills, but the text isn't necessarily available at this point in time. But you can see they're working on them, and there's 3 bills where you can see that they're working on drafts. In Arkansas, deepfakes in elections, I think we'll see a ton of things with respect to elections. Okay, let me turn it over to Owen, and Owen's going to talk to you about the rulemaking process in California and a couple of different topics.
Thanks, Dave. So we're returning to California. So the California Privacy Protection Agency Board has put out a set of proposed regulations, new regulations under the CCPA. We're just going to be talking about one sliver of that concerns automated decision-making technology, AI. So the formal rulemaking process started in November. It's currently under a comment period that ends in January. It's difficult to predict, but based on precedent, we would expect these regulations to become effective in roughly 6 to 9 months, but there are a lot of variables that can apply there. So looking at the regulations as they're currently proposed, now remember, these are just proposals, nothing's final yet. But these regulations would apply to automated decision-making technology, which is defined as any technology that processes personal information and uses computation to execute a decision, replace human decision-making, or substantially facilitate human decision-making. The key there is the processing of personal information. Again, these regulations are being proposed, under the slides are changing on me, to be proposed under the CCPA. The general structure of how these regulations will work is that you have an ADMT, and then you are using that ADMT in kind of one of these 3 activities here: significant decision concerning consumers, extensive profiling, or training uses of ADMT. So when it comes to significant decisions, this chart should look familiar to you. It's very similar to what we see in the Colorado AI Act. It's about using these technologies to make significant decisions in these areas of people's lives. One caveat is that you have to use the information. The information you're using for the ADMT has to be subject to the CCPA. So any exemptions under the CCPA would also apply to these regulations. So in other words, I think there is going to be a scoping issue with how these regulations will apply when considering what type of data is excluded under the CCPA. Extensive profiling, the regulations provide 3 types of extensive profiling: worker education profiling, public profiling, profiling a consumer for behavioral advertising. One thing to note here is that part of the set of proposed regulations we've seen from the board includes proposed rules around completing risk assessments, and some of these activities or uses of ADMT can trigger those risk assessment obligations. Finally, the last activity being subject to these regulations is the training of ADMT. If you're training ADMT to do any of these 4 categories of activities, then the regulations would apply in that scenario. Once you realize that the ADMT you have is subject to the requirements essentially fall into these 3 categories that are very similar to people familiar with the CCPA. Again, sorry, it seems the slides keep jumping on me. There's a pre-use notice about the use of the technology, a right to opt out from being subject to the technology for consumers, and then a right to access for consumers, right to access information about the technology that you're using. Okay, let's see if we can get this working. All right, I know that was a very brief, quick overview of those ADMT regulations. As Dave mentioned, these proposed rules, not just with ADMT, but other categories, highly nuanced. We have these webinars on our website where you can, where we get more into the weeds on these proposed draft regulations. So please take a look at those when you have the time. All right, staying in California, we're going to move to another set of proposed regulations. These are from the Civil Rights Department in California. These are very similar to what we saw in the Illinois bill that I discussed earlier that passed last year. It's essentially amending or adding rules under the enforcement of California's Fair Employment and Housing Act, essentially the anti-discrimination law in California, to include automated decision systems. Now, helpfully, this is different from automated ADMTs. We're using a different term here. As you can see in the definition, though, it's similar, but there's not the same focus on the personal information that's being processed in the technology. These rules were first proposed in May of last year. There was an additional 30-day comment period that ended last month. So we'll see if there are any changes following that, that comment period. But as the proposed rules currently stand, it essentially says you can't use automated decision systems to discriminate people on a basis of a protected class. There is a provision that suggests a potential defense to such claims if you are testing the system that you're using to show that it's not biased, but there is not a specific obligation that you run these these bias audits that we see in other bills. It's important to keep in mind that the current rules under the anti-discrimination statute would also then now apply to automated decision systems. So this includes, accommodation requirements and then also record keeping requirements. One thing to note there is that the regulations propose extending the record keeping requirement from 2 years to 4 years. All right, so moving forward, I'm going to pass on to Shelby, I believe, to talk about the Colorado AI Task Force.
Yes, so back to Colorado's AI Act. As I mentioned earlier, Colorado has created an AI Impact Task Force that is charged with submitting recommendations to the Joint Technology Committee and Governor's Office by February 1st. So only in a few short months. The task force is made up of lawmakers, business leaders, consumer advocates, and academics. The task force has held 3 meetings so far and has a 4th meeting set for next week on the 20th. And during these meetings, different organizations and businesses have the opportunity to present, and there's an open discussion. So here on this first slide, we kind of walk through the pros and cons that have been discussed of AI in general during these task force meetings. But since we're short on time, I want to flip over to the findings. Outside of overall discussions on AI, the meetings focus on the Colorado AI Act, and we highlight both positive and negative aspects that we have pulled from those meetings. During the meetings, representatives from organizations have praised the law for multiple aspects, including the requirement to complete impact assessments and document discrimination risks, the requirement to provide notice to consumers who are the subject of AI-driven decisions, and there has been praise that the law is going to be enforced exclusively by the Colorado AG's office, especially considering the fact that the AG has the ability to issue rules that interpret and clarify the law. On the other hand, we do have representatives that have criticized the law. Many representatives from startup companies have argued that the overly broad language in the law is going to hinder their process to become compliant. So during the meetings, there are representatives from many different companies of all sizes who gave their opinion. But when it comes to providing the most criticism, the vast majority are being voiced by small businesses. Colorado is the #1 state for startups and private capital investment opportunities. And representatives have voiced that this is largely due to a consistent, accessible, and reliable environment. So we put together a list of potential outcomes that individuals expressed during the meeting that could be consequences of the AI Act going into effect as currently written, including a reduction in innovation, challenges for implementing public services, decreased technology talent, and limitation on accessibility efforts. The last piece of input was from a member of the AG's office, and he really emphasized that the following actions should be taken with regards to the AI law, including evaluating whether any AI-specific measures are necessary and appropriate, avoiding adopting regulations that only the industry leaders can comply with, and evaluating whether oversight of an emerging technology will push development elsewhere or raise costs. So based on these meetings, there are very strong feelings about this law, and it really remains to be seen what changes will be made to the law before it goes into effect on February 1st, 2026. So I am going to pass it back to Dave to close us out.
Yeah, thanks, Shelby. So let me end on this. We've been talking a lot today about what must feel like a fire hose, right? It does to us, right? So we've identified a problem, but maybe we can suggest to you a solution or at least something to help along the way. If you subscribe to our blog Bite Back for the last year, you know we've pushed out occasional emails and updates on AI bills, but we did those basically once every 4 to 6 weeks, and the scope was fairly limited. We want to do more this year, and I think we're going to see hundreds and hundreds of bills and regulation, not hundreds of bills, and we're going to see also regulations in California, Illinois, for example. What we came up with basically was this idea of Bite Back AI. It's a newsletter. It's going to be a weekly newsletter, tracking the bills and the regulations at the state level, summaries of hearings, bill tracker charts, and special features. We're really excited about this. But this is how it's going to work. We're going to start these newsletters on December 23rd. We're going to do 2 free, okay? The 23rd of December and the 30th of December. We're going to do free ones, and then we're going to start a subscriber-only access on January 6th. This is the subscriber level. Obviously, it's, you do it, don't do it. It's obviously completely up to you. There's individual options. There's monthly options. There's also enterprise level for folks. So, up to three people from the same organization could get subscriber pricing to get these weekly newsletters. The QR code, basically what we've done is we've opened up a wait list for this. If you've already put your information in, don't worry about it. We're not billing you anything. It's just basically a wait list to say, hey, when you guys spin this up on January 6th, we'd be interested in hearing more information about this, being contacted about this service. Again, the whole idea is to provide at what I think is a reasonable cost, a way for you guys to get on top of this issue, get weekly updates, tracker charts, what's new sections and special features. So we've heard a lot from clients on this issue about wanting this type of stuff, and non-clients as well. And we're hoping that this kind of meets it. But when I say finally on this one, I know we're out of it. If you're a government official, you're a lawmaker, you're a government official, I know there's a lot of you out there who watch and you rely on our tracking. I'm going to give it to you for free. Okay. So just email me and we'll get you signed up for this one. Okay. Finally, lastly, we always end on this slide here. Subscribe to our blog if you're not already subscribed. Just the QR code, and again, you'll get those 2 free newsletters through the blog if not already subscribed. Okay, we've hit our time. We always feel like we're always stretched for time on these webinars. Really appreciate everybody attending today. Hopefully, you got a lot out of it, and we'll see you on the next one. Thank you.